sir, HOD of Mechanical Department Anil Kumar sir, Kalesh sir, IEDC Department Coordinator, respected Viju sir, IIC Department Coordinator, and our honorable guest. Let us start today's session with silent prayer. Thank you. First, I would like to invite Kalesh sir to give the welcome speech.
Respected Principal Dr. Sanjeev sir, our Department HOD Mr. Kumar sir, and our distinguished chief guest Dr. JIPPU JACOB sir, and my dear colleagues and dear students, a warm good morning to one and all. So the duty entrusted upon me is to welcome our chief guest and all other assembled here. First of all, I would like to welcome our beloved Principal Dr. Sanjeev sir to this function. Next, I would like to welcome our HOD Mr. Anil Kumar sir, who is the backbone of our department, who is giving all support to our all ventures related to academic and non-academic matters. Welcome you sir to this function. Next, our chief guest Dr. JIPPU JACOB sir is a busy person. He is traveling across over the Kerala and India and conducting different events related to intellectual property rights and patents. So during his busy schedule, he received our invitation and share his valuable time with us. Welcome you sir to this function. Next, I would like to welcome my colleagues, IAC Coordinator Viju sir, then IEDC Coordinator Gayatri Miss, and all other faculty members and my dear students. Welcome all of you to this function. Thank you. Have a nice day.
Today, here we have with us Mr. JIPPU JACOB sir to talk about intellectual property rights. He is a mechanical engineer and has a specialization in agriculture machinery. He is a passionate innovator and has 3 patents in his name for Gopner dehusking machine, an attachment for making basins around trees, a bicycle type milking machine for dairy farms. He has a degree in BSc Engineering from Allahabad University, and he has achieved his MTech and PhD from IIT Kharagpur. He has worked in Kerala Agriculture University for 33 years and held the position of Dean, Faculty of Engineering and Technology. He is currently working in Amal Jyoti College of Engineering as Adjunct Professor and Coordinator IPR. He has recognitions of Eminent Engineer conferred by Institution of Engineers, a certificate of award for the invention of a Gopner dehusking tool by the National Research Development Corporation. Please welcome Mr. JIPPU JACOB sir. I would like to hand over the session to Mr. JIPPU JACOB sir.
To the Principal, Vice Principal, Management, Professor Kalesh, and the rest of the staff for having extended to me this opportunity of making a presentation on intellectual property rights. And I also welcome all of you to this presentation. Secondly, I am sorry for being late. It's because of the road construction going all over, and because of that I couldn't speed up to the level I wanted. Otherwise I would have been here right on time. I think we'll move on, straight away move on, since the time is short. We'll straight away move on to the topic. As you can see, it is an overview of the intellectual property rights. Next slide. ചില പറയാറുണ്ട് ഞാൻ സ്വയം വളർന്ന ഈ നിലയിലെത്തിയതാണ്. What do you say? What is your opinion? Did you come up to this level because of your own effort? No. Yeah. One sitting here. You are calling the other person. Yeah. Did you reach up to this level because of your own effort? No. We agree. Okay, next slide please. But did you born or give birth to you to given by someone else. How about the name? What is your name? Salman. Okay. Did you get the name? Did you name it yourself? Someone else named it. Okay. Income is to be given by others. Whether you are an entrepreneur, whether you are working for someone else, money has to be given by someone else. You can't mint money. So respect is to be given by others. So all these things, first and last path. Is there anyone who has taken the first path himself or herself? So here, after your death, your property will be taken over by others, funeral services will be done by others. Then still wonder why we have all the unnecessary ego problems. I have seen many people with this attitude or ego that I am a Superman. Nothing. Whatever you are wearing now, your shirt, everything is given by others. So there is no necessity for having this sort of a ego. That's like this. So ഈ ലോകത്തിൽ ആർക്കും മറ്റുള്ളവരുടെ പിന്തുണയും സഹായവും ഇല്ലാതെ ഒന്നും തന്നെ നേടാനാവില്ല. Next slide. Nothing in the nature lives for itself. Rivers don't drink their own water. They supply to others, to the animals, to the birds, to the trees, to the earth. Fruits don't eat their own fruits. They are giving to the birds, animals, man, and so on. Sun doesn't give heat for itself. Flowers don't spread fragrance for themselves. And therefore, living for others is the role of nature. Living for others is the role of nature. Next slide. നിങ്ങൾ ഇപ്പോഴത്തെ നിലയിലെത്താൻ പ്രത്യക്ഷമായോ പരോക്ഷമായോ സഹായിച്ച എല്ലാവരോടും നന്ദിയുള്ളവരാണ്. So now you understand what your position is. Everything we are having in our possession is because of others. So we have to show gratitude to others, to those in the society. Because none of this we didn't bring into existence. So do that through your innovations. You are basically engineers. And therefore, there are many ways of expressing your gratitude to others. Or you can give him food, you can give him money. So there are ever so many methods of expressing your gratitude. But as engineers, or those who are involved in technology and engineering can do that better through innovations. So my point is that we have to do innovations. As engineers, particularly as I think all of you are mechanical engineers, we can do it through developing machines, and can be of that those such machines can become useful to others in the society, and that is showing your gratitude. Next slide, please. When we talk about innovation, we have to consider the growth GDP, one of the primary indicators used to gauge the health of a country's economy. Wealth is. There are two types of wealth. One is the tangible property and the other one is the intangible property. Under tangible property, you have two classes. One is movable property. Here you can see a stapler is there, which is a movable property. The chair is here, which is also a movable property. I need not explain. Second one is immovable property, like the building. It is immovable. But still, it is something which can be perceptible by touch. When we say tangible property, it is something which can be felt by touch, perceptible by touch. And then the second category is intangible property, which is not having physical presence. When we say intellectual property, it comes out of your brain and then you create something out of that. So what you have in your mind, your idea, and that is basically intellectual property, which is not having any physical presence, so it is known as intellectual property. Next slide, please. What is intellectual property? Next slide. Creations of human intellect. It is a creation of human intellect, which consists of the products of mind, consists of an idea plus a creation. Not only it is enough to have an idea. If you have an idea, if you don't put it to work, if you don't bring it into existence, what is the use with that idea? No use with that idea. As I said, since others are supporting us, we have to show gratitude to others. It has to be through innovations. If innovations has to take place, you need to have an idea, you have to create it, and definitely it becomes accessible to others. Just by having an idea, it's like you got 1 lakh rupees with you. You put it in a box, keep it under your cot. You are not spending it for your needs. What is the use with that money? You can say that, okay, I have 1 lakh rupees with me, but you are not spending for any of your needs. You are not buying mobile, you are not buying books. What is the use with that money? Like that, if you have an idea, if you don't put it into practice, what is the use with that idea? Illegal possession of immovable property. You cannot take away immovable property, but there is a forcible possession. Someone may come in and force you out illegally. This person was staying in a house, he has been checked out. So that is forcible possession. Next one. An illegal possession of intellectual property. This fellow is making some art and he is plagiarizing it. Simply looking at it and whatever the other fellow is doing is reproducing it. And this fellow is running away. Cartoon and plagiarism, hey, that's my idea. So the other fellow is running away with another person's idea. Next slide. And therefore, you have movable property, immovable property, intellectual property, and then illegal possession, you call it stealing. This one is occupation, forcible occupation, illegal occupation. And the last one is infringement. Now we are concerned with the last one, that is intellectual property dispossession, which is known as infringement. Next one. Infringement is the action of breaking the terms of a law, agreement, etc., which is a violation. It is the breaking of the terms of a law or agreement. Example, copyright infringement. You often hear about copyright infringement. Or an infringement of the trademark. Next one. Illegal possession is protected by the law of the land. We have mechanisms for that. Since police is there, or maybe the courts are there. Different levels of courts are there. So all they will take care of the infringement which is caused. Next one. So intellectual property, you got to protect it. This fellow is running away with your like plagiarism. Next one. No trespassing, keep our private property. This Takata board you can see it at many places. It's a private property, no trespassing. It's applicable to intellectual property also. You have the right, someone is trying to copy it and duplicating it, which is again the next one is. So for that, know your rights. Know your rights. That is why all of you are here, to know what your rights are relating to intellectual property, not about tangible property, intangible property. Next one please. In India, every country has their own types of IPRs. What is applicable to us need not be applicable to the Americans. So as far as copyright is concerned, our software comes under copyright, but in America it comes under patent. So first I will take copyright. you have heard a lot about copyrights. Next one. This is my blue book of grammar written by one of my professors in my college. It's being used in the schools when they are studying grammar, English grammar. Next slide. So here you can see this is published by Shared Publishing House. The publisher is Shared Publishing House. He has a copy, this professor has a copyright. He licensed it to Shared Brothers. They are the publishers. He has transferred the right to them. They have a set of conditions for that. The publisher has to abide by the conditions. If they break the conditions, it becomes infringement and he can be penalized through a court of law. So here you can see there is a sign. Let us see and circle. That is the indication to show that this book is copyrighted. What does it say? All rights are reserved. All rights are reserved. No part of this publication may be reproduced, stored in, or introduced into a retrieval system transmitted in any form by any means without prior written permission of the publisher. So without the publishers, so he has transferred the right to the publisher. And therefore, only you cannot do it without the prior written permission of the publisher, not the author. He can keep it as well. If he is a publisher, he can do it himself. So this condition will be applicable to the publisher, the author. But here he has transferred the right to the publisher, and therefore publisher is saying that only if one has the permission of the publisher that can be copied, reproduced. But there are certain exemptions for that. Next one. Say here a photograph. A photograph is also copyrighted. Next one, here it is written. And different symbols are used to show that it is copyrighted. All these are indicative of that. Copy, all right reserved, copyrighted, all right reserved. So different ways it can be shown for the knowledge of others. Next one. Copyright applies to a lot of things. Artistic, literary work, dramatic works, musical works, cinematographic film, sound recording and software. Recently there was a conflict I think with Vishuras and someone else, because songs are copyrighted, because he is singing it. It's written by someone else. It's written by someone else and he is singing it. So only because he is singing it that people are listening to it. If I am singing that same song, nobody will listen. So quality is imparted to the song by Yeshudas or any singer of that matter. That is why the right is given to the singer also, along with the writer. Next one. So all these things are there. It works in the original work only. Right exists only in the work, not in the copy. Registration of copyright in India is not mandatory. It's not necessary. But in case someone is infringing your rights, where will you go? You have to go to the court of law. Court of law will ask whether you are a copyright given by the government of India. Only then it becomes valid, your argument becomes valid. Otherwise simply the court will throw off your petition. So if you are interested in making use of your copyright, have it granted by the government. There are mechanisms for that. Next one. As India is concerned, we have enough raw materials. Natural resources are. Second one is human resources. That also India is not ranking behind. We have too many people living in the country, and because of that now people are going to other countries and working there. So enough human resources are. And the last one is what it matters to us, technology and innovations. Unless a country has enough technology and innovations, our GDP will come down. So as I said, India is rich in human resources and also rich in natural resources. So we are happy with that. But how about innovations and technologies? We were under colonial rule for some time. In 1947, we were under the colonial rule. And because of that, they exploited us. They took away some of our resources, and our foreign exchange also they limited us. They would supply us some materials and they would take away excess cash from us. So India suffered till 1947 due to lack of technology and innovations. But our wise planners, administrators, technologists, they built up a system where innovations could be taken up, technology could be developed. Now we are they kept on building up the infrastructure necessary to generate technology and innovations. So now we are almost come to a very good level, and because of that, we are in a position to take up innovations and technology in a big way. Yes, sir. Our Prime Minister very rightly said, come make in India. Come make in India. Many of the Indians went abroad and served the other countries. And we suffered because of that. As I said, planners, administrators, etc., after the independence, they built up our infrastructure. But at the same time, those who are capable of developing technology and innovations, they are as well. So, now importance is given to invite them to India, let them invest in India, and then let us make our life better. That's what he said, come make in India. Next slide. But what is it that we are making? When he says, come make in India, it is to be a product. What is it that we are making? It is nothing but a product. What is a product? It is nothing but an innovation. And therefore we will restate what the Prime Minister said, next slide please. Come innovate in India. If you want to make it in India, then we should be giving our attention to innovating in India. And then otherwise we can bring the technology from other countries, paying a very heavy price. So that will be depleting our foreign exchange. So if we want to reserve and conserve our foreign exchange, then we have to innovate in India. And who will do that? You have to do that. Each one sitting here has to do that. Make in India. Innovate in India. That's right. It is time for Indians to take up their rightful place on the global arena of creativity and innovation, not only as creators and innovators, but also as owners of IP. If you develop something, if you own the property, intellectual property right for that, maybe that you have obtained a IPR or a patent in the United States for a thing which has been developed in India, but you have taken the IPR or the patent in America. Then whatever you are selling or producing in America, you get money, and which can be routed to India as well. College life was 60 years for literary, artistic and musical, 60 years for photographic work. For this particular one, you get doctor's work. Altogether you get it for 60 years. Here also all these government works, sound recording, you have for 60 years. Next one. Related rights. Related rights. Rights of persons or organizations who have substantial creative skill, technical skill, or organized in the process of bringing a work available to the public. That's what I said. Somebody has said, all we could do has written a song. When Yeshidas is singing, it adds substantial creative skill, organizational skill, etc. If I am singing, it's not. Nobody is going to listen to it. So it's all related rights. R&B gets a right, copyright, because he has written it. And Yeshidas has related rights. The singer has related rights. Okay? So if anyone of you sitting here writing a song and someone else is singing it, mind that you want to have a copyright down, have these things in your mind. Next one. It's a protection to performing artists. Mohanlal, when he is acting, something, people enjoy it. Are you a good actor? Yeah? No. If you are acting, will anyone see? No. So, please guarantee performing art, protection to performing artists, producers of photographs, broadcasting organization, financial resources, all these things are there. Next one. Next is trademarks in India. Next one. You are familiar with all this. What is this? What is this? Starbucks coffee. These are all well-known trademarks. It assures certain quality. When you see there is a shop where what is written, you are assured that the produce they are doing or the products which they have met certain standards. Next one. There are different types of trademarks. One is product trademarks, like Maggi, etc. Service trademarks, Axis Bank, DHL, Sri Buddha product. That's also a service trademark. What is the service which Sri Buddha College is giving? Education. Education is a service. Certification of trademarks, ACMA, Moonmark, etc. You heard about ACMA. Then Kalati marks, doctors, CA, Khadi, FIFA, etc. Doctors emblem you can see, which is a trademark. Continuous also you can see. Then unrelated trademarks, Apple, BlackBerry. Apple is what? Computer, isn't it? And what is basically Apple? Apple is a fruit. Is there any connection between fruit and the computer? No. That is why it is known as unrelated trademarks. BlackBerry, it's also a fruit. Well-known trademarks, Pepsi, Samsung, etc. They are all well-known trademarks. Next one. Previous slide. Okay. Next one. A mark capable of being represented graphically and capable of distinguishing the goods or services of one person from those of others. May include shape of goods, the packaging, combination of colors, etc. Next one. It's a trademark. By the side it is written R. It indicates registered trademark. Registered with the Government of India. Registered with the trademark office. Simply writing trademark without R may indicate that it is not a registered one. We can have a trademark. And can use it anywhere as a mask. But if someone is copying that and making it their own, I cannot go to the court of law. If you want to go to the court of law for any sort of infringement about your trademark, I have also written against. Next one. Mark includes a device, brand, heading, label, ticket, name, signature, etc. Next one. Trademark can be a word like IPO. It can be Annapurna, or Kisan. It's a name. It can be made out of devices, figurative elements, logos can be there. Like this, G, triple H, etc. Next one. Examples of trademark. Many of them, all of them must be familiar with. Next one. This Starbucks has undergone a change over a period of time. This was in 1971. Their trademark was like this. They thought something is to be incorporated and something is to be eliminated. This 87, this came into existence. 92, this came into existence. And 2011, this came into existence. Here you can see spices, tea, coffee. And here they restricted it to coffee alone. So that way, if you have a trademark, you can change it also, depending upon your requirement. Next one. So it must not be descriptive. Say Bata has written Bata. They could have written Bata shoes are much better as a logo. Don't do that. Always should not be descriptive, must not be deceptively similar to known or well-known trademarks. I will come to that later. Avoid using geographical indications. Deities, Devatayana meche trademark ondakamba. National leaders, heroes, symbols, laudatory words. All these are prevented. If you apply to the trademark office with these sort of things, outright they will reject it. You will not get it. Next one. Which fridge is this? All of you know that it is a Godrej fridge. Next slide. Which Almirah is this? Godrej. All of you agree. Next one. Now, this is Godrej. Spell all the word letters in this. Read all the letters in this. After G-O, what is that? Where is an R? Earlier I said it should not be deceptively similar. It should not be deceptively similar. Now, I have a fridge which is Godrej. In my office, when I occupied it, there was an Almirah like this. This Almirah. The photo is that of this Almirah. I thought it is Godrej Almirah, but quality was not that good. When I prepared slides for these sort of presentations earlier, somehow it came to my mind that there is an R in between O and D. That is only when I realized it. See how cleverly they have, it must be cheating many people. Godrej can give, I don't know whether they have come to know about it. If it is, they can file a suit against them. They can file a suit against the manufacturer of the Godrej Almirah. I don't know whether they have done it. And they would have been in trouble because you cannot have a trademark deceptively similar to a registered trademark. Cannot be registered trademark. If a Godrej is a registered trademark. Okay, next one. So I just wanted to show that deceptively how people are using it. Now service trademarks. I was mentioning so far about the products. Now here, capable of distributing services. Education. Whose logo is this? Whose logo is this? Your logo. Isn't it? It's the logo of the Sribuddha College of Engineering Pattur. ആരും കണ്ടിട്ടില്ലേ? ആരും ഒരു കോൺഫിഡൻസ് ആയിട്ട് പറയുന്നില്ലല്ലോ അത് ശ്രീബുദ്ധയുടെ ലോഗോ ആണെന്ന്. ഓക്കെ, യു നോ ദിസ് Indian Railways, of course, CSIR, they are all service trademark. Insurance company, LIC, banking, South Indian Bank, SBI, hotels, laundry, transport, research laboratories, etc. So all these are having trademarks. Next one. You know this Google. Next one. These are collective trademarks. Collective trademarks. Whose doctors? IMA is owning this trademark. This one? Chartered accountants. This is the logo of the chartered accountants. Trademark. Next one. Owned by an association, collective trademark. Like doctors, altogether, IMA, whose members use them to identify themselves with a level of quality and other requirements set by the association. You must have read that some doctors have become highly unethical and they have done some mischief, and their membership will be cancelled. It was cancelled from IMA. So they are not allowed to use this trademark. You can see on the car, this trademark is there. So a person who has been removed from the rolls of IMA cannot use this trademark. So it is maintaining certain quality. Next one. Trademark versus brand name. You can see here, identifies and promotes a company. Corporate brand name. Brand name is promoting a company, whereas product identifies a particular product. Isn't it? Okay? Brand, when you say brand name, it is showing the company. Trademark, it is showing the product, what the product is. Coca-Cola. Coca-Cola is the brand name of the company. And what is basically Coca-Cola? It is Coke Zero. Like that, Toyota Motor Company has got a car by the name Corolla. Who is manufacturing it? Toyota Motor Company. Next one. What should I use? R, trademark. Which one you should be using? You can use TM also, but along with that you have got to write R. Then it shows that it is a registered trademark. Otherwise, it is an unregistered trademark. Next one. Trademark, you have to do a trademark search in the trademark journal of the government of India and see, say you want to have a trademark for your product. Then search and find out the type of logo which you want. Something similar to that is already existing. That you can find it in the journal. If it is there, don't try for that, because they should not be deceptively similar. Godrej and Godrej. So have that in your mind. Next one. These are the offices where you can apply designs and trademark: Mumbai, Ahmedabad, Calcutta, New Delhi, Chennai. We should be applying in the southern region, should be applying in the Chennai region. Next one. How to apply all these things are there. I am not going into the details of that. Next one. Next one. Procedure, you have to file, they will examine it, and if there are any objections, they will let you know. You have to clarify it, substantiate your claims, and then you can apply, they will grant it. Next one. Next one. These are all the fees for that. Again, refer to this particular site for getting the up-to-date information. Next one. Registered trademark to be renewed after every 10 years. If you have a registered trademark, it should be renewed at every 10 years. Is there such a renewal in the case of copyright? It was not there. Say cinematographic film, it was for 60 years altogether. Sound recording, 60 years. But for literary work, 60 years beyond the death of the author. So this particular one, every 10 years you have got to, if you want to keep its validity, keep on reviving it or renewing it every 10 years. And it can be for unlimited period. The other one for 60 years. Or others lifetime plus 60 years. There is a stop to that. But here it is unlimited. For any number of years it can be there, provided you renew it. Next one. This is the trademark journal where you can find all the trademarks. Next one. Next one is design in India. Third one. Next. Say here this bottle, it has shown 5 views. This is one view. Maybe from the front view. This may be left hand view. This could be a right side view. This could be the rear one. And this could be after tilting it. You can see the bottom also. You can have any number of views. That is indicating that what are the characteristics of your design. What are all the figure? Here in the front, on the side, on the right side, on behind, and from below as well. So if someone is violating it, the design office will check whether all these are there. Next one. It can be registered also, as you can see the R letter is there. Car body shapes are good examples of registered designs. Manufacturers want to stop other companies copying successfully styled cars. Even if the technology inside the car is too similar to the previous models to be able to patent them, distinctive features such as radiator grills can be protected as well as the overall body shape. Mercedes-Benz, for instance, or Rolls-Royce, they maintain almost the same type of grill. So that is the design. They are maintaining it. They have registered it. Next one. Design means only features of shape, configuration, pattern, ornament, or composition of lines or colors. You can do it to lines, you can do it to colors as well. Apply to an article whether in 2 or 3 dimensions or both forms. Next one. By any industrial process or means, you should be able to do it. Lines are drawn through some industrial means. Whether manual, mechanical, chemical, separately or combined, which in the finished article, this is more important in the case of the design, appeal to the eye. How it appeals to the eye, that is important. Not the technical features of that. Aesthetically, how it appears to one. Judged solely by the eye. Design is judged solely by the eye. Next one. Okay, leave it. So all the things you have got to apply when you have to. Next one. Next one. Design to be renewed after 10 years. Like trademark, every 10 years you have got to renew it. And whatever the term of design. Term of design is for 15 years. You can have the right for only 15 years. Otherwise, it becomes monotonous for the whole. Every now and then, the car people, they are changing the car body shape, etc. Fan also they are changing. Anything that you take, they keep on changing it. Otherwise it becomes monotonous. That is why it is given only 15 years lifetime. Next one. Next, this is what is more important to you, patents in India. Next one. Given by the patents is the registrar's office. Next one. What is a patent? Patent is a statutory right for an invention. It is a statutory right for an invention, granted for a limited period to the patentee by the government. To whom it is granted? To the patentee. Who is granting it? By the government. And for limited period. In exchange, a full disclosure of your invention. When you apply for a patent, you have to describe your invention. What are all the components? How they are arranged? How it works? All these details have got to be submitted to the patent office. So it is an exchange of the details. For what? For excluding others from making. Others cannot make without the permission of the patentee. For using. Say I go to the shop and buy a stapler, which is a patented product. I have not obtained any permission from either from the industry or from the patentee, but I am using it. But it is a product manufactured by a licensed manufacturer. It is a product manufactured by a licensed manufacturer. So he has distributed to me. Therefore, there is no objection. Next one. Previous. So selling also you cannot do. Importing also you cannot do. Importing the patented product or process for producing that product for those purposes without his consent. Next one. This is the act which is governing the patents. Act of 1970. It is undergoing amendments now and then. Next one. What is an invention? It is any new and useful. It should be new. It should be useful as well. What? Art to be a process, method or manner of manufacture. How you are manufacturing. Machine, apparatus or other article. Substance produced by manufacture, tablet. It's a substance produced by manufacture. And includes any new and useful improvement. Any new and useful improvement. Say a microphone. This one, the cable is connected to it. How about this one? Both have the same function. Both have the same function. But this particular one, the cable is there. This is without the cable. Which is more advantageous? Of course, we would say, had it been working well, this would have been a better one. You can, without the disturbance of the cable, one can use it. And that is a new and useful improvement. It is a new and useful improvement. Both are microphones. And what is the improvement? Remove the cable. Remove the cable. That is the new and useful improvement. Next one. Should application, don't look at the serial number. Should application for patent be filed before or after publication of the details of invention? This is a mistake committed by most of the inventors or patent, those who apply for patent. When you invent something or innovate something, you are very eager to make it known to the public. You are very eager to make it known to the public. So you will call the press conference or catch hold of a press reporter, will leave all the details to him, he will publish it in the paper, and then you apply for the patent. Patent office may come to know of this paper report, so they would simply say yours is lacking in novelty because it's already published. So don't publish it. If you have any intention of applying for a patent, don't publish it. So, to be filed before publication of the invention. To be filed before the publication of the invention. And till then should not be disclosed or published. Till you apply for the patent, and here too, novelty is verified as on the date and time of receipt of application in the Indian Post Patent Office. Time and date. Suppose one wants to apply for a patent. He has drafted the whole thing, that all applications are complete. You take it to the Chennai Patent Office. You file it there at 11 o'clock. You file it at exactly at 11 o'clock. Another person, maybe that he has seen your invention, he also drafts a patent application, takes it to the patent office, files at 11, not 1 second. Just 1 second after you have published it. Who gets the priority? You get the priority. On the other hand, it is your product, the other person has copied it, he goes and files it at 11 o'clock, you files at 11 and 1 second. Who will get it? The other person, even though it is your invention, it is the other person who is going to get it. So make sure that if you have an invention, don't publish it anywhere, but till you file an application in the patent office. Ensure that at what time it has been received in the patent office. That is important. Maybe that you draft it today, you sign it today, send it by post, and they receive it at maybe tomorrow. So your priority starts only from tomorrow. Your priority starts only from tomorrow. So what is the time at which it has been received in the patent office? That is more important. It is based on that novelty is fixed. So don't try to publish anything, but there are certain exemptions. Novelty verified, and however, under certain conditions there is a grace period of 12 months. Next slide. Generally, can any invention be patented after publication or display in the public exhibition? Don't exhibit it before others. Earlier I mentioned about publication. Don't exhibit it also anywhere. Maybe that Sri Buddha College is organizing an exhibition, you have a new product, new invention, out of your eagerness, you display it in the exhibition, and then you apply for a patent. If patent office comes to know that it has been exhibited here, and only after that you have applied for the patent, it will be straight away denied. So don't publish it, don't display it at any exhibition. Again, there are certain conditions. Exemptions are there. But the Patent Act allows a grace period of 12 months for filing the patent application from the date of its publication in the journal. If you are publishing it in a scientific journal, then you may be exempted, provided you apply within 12 months of publication. After 12 months you apply, you are likely to get it. Similarly, public display in an exhibition organized by the government. Say College of Engineering in Trivandrum is organizing an exhibition. You go and display it there. But you are applying it within 12 months. Therefore, you have the right to get it, provided other conditions are satisfied. But even though you have applied it in the since you have applied it in the government, you get 12 months time. But Sri Buddha exhibition, you won't have that because it's a private exhibition. So try to understand that. Next one. Next one. The fifth one is integrated circuits. Layout of integrated circuits are also eligible for rights. Those are property rights, like the others. Next one. Layout of transistors and other circuit elements, including lead wires, connecting such elements expressed in a manner in semiconductor integrated circuit. These are eligible for IC layout design rights. Next one. Our creations of human mind. They are creations of human mind. There is a lot of investment of time and money in the creation, but copying is very cheap and easy as well. That is why you have the protection for that, because you have labored so much and then you come up with an integrated circuit. Someone can very easily copy. That is what most of the people are doing also. They buy the product, open it, disassemble it, see what the circuits are, and they will incorporate something similar to that and they sell it. Next one. Act of reproducing your layout design fully or in parts, importing, selling, distributing commercially protected layout design. All these are taken care of. Next one. It has to be original. Your IC has got to be original. It should not be existing anywhere. It should be distinctive from others, capable of distinguishing from any other layout design. And it is for 10 years from the date of filing an application. Next one. Geographical indications. You have heard of Banaras sari, Pochampalli saris, Darjeeling tea. All these are related to a geographical area. All these are related to geographical area. Next one. See here. Customers must not be misled. Marking must not mislead. No dilution. Economic prosperity has to be there. Darjeeling tea, Basmati rice, Kolhapuri chappals, Nagpur orange, Scotch whiskey, etc. All these are geographical indications. Next one. Say Darjeeling tea, this is the sign, symbol. So if this symbol is there, no one can use it illegally. They are not permitted. They are likely to be prosecuted. But otherwise, if you see the symbol, it's an assurance that it's a quality product. This tea, if you buy, it is from Darjeeling and therefore it is having all the qualities, all the properties. Next one. Kanchipuram sari. Next one. Mysore silk. Coimbatore wag grinder. This Coimbatore wag grinder, there are others also manufacturing wag grinder. How it differs from why geographical indication rights has been given to Coimbatore, because they are taking the stones. The granite stones are used in this. Those are of much better quality. They won't get abraded easily. They won't get abraded easily. If you buy these grinders made from locally, as you start grinding, half of your batter will be powder, granite powder, because it is easily abrading. But the one which has the geographical indication rights of Coimbatore wag grinder, it assures certain quality that it won't get easily abraded. The other one may abrade, and your product may contain sand particles. Next one. So all these are there. We have a GIs from Kerala. Lot of GIs are there from Kerala. Spices, Alapi, green cardamom. But the funny part is that Alapi doesn't have any cardamom at all. Alapi doesn't produce cardamom anywhere in that district. It's all done in the high ranges and so on. It is brought to Alapi and then disposed from there. That is why it has that name. Only very few things are having such a name. Means it's not related to that particular thing, but Alapi cardamom, they ensure that it is taken from reliable sources. They take it from reliable sources. So it is almost assured that when you buy it as Alapi cardamom, it is from a good area. Similarly, Aramula Kannadi is produced in Aramula itself. Then Navara rice, Palakkad Matta rice, Malappa pepper, Vadapalam pineapple, all these things are there. They are all geographical indications connected with Kerala. Next one. Next one. These are all the fees. Is for a period of 10 years. It has to be renewed indefinitely and so on. Next one. The next one is trade secret. Trade secret. Rest of the things, all the 6 things which I mentioned earlier, you have got to disclose it. You have got to disclose it. If it is a copyright, you have to show what you have written. If it is a related merit, how Yeshu has sung that. Similarly, trademark, what the trademarks are. Patents, what you have produced. But here, you need not disclose it. Best example is Coca-Cola. Does anyone know the formula of Coca-Cola? It is the best kept secret. Only 3 or 4 people know that. The formula which cannot be disclosed before others, that can be kept as trade secret. Next one. Some inventions, data, information cannot be protected by any of the available means of it, is held confidential as a trade secret. Trade secret can be an invention, idea, survey method, manufacturing process, experimental research. All these things can come under trade secret. Next one. When trade secrets are preferred, when invention is not patentable. Because if it is to be patented, you have to disclose what, you have to describe what your invention is. So here you are not doing it. And therefore, plant protection is limited to 20, patent protection is limited to 20 years. So here in this case, for the trade secret is done to 20 years, then secret can be kept beyond that period. That is what Coca-Cola has done. Coca-Cola has a trade, as keeping it as a trade secret. I think it is maybe 30 or 40 years since Coca-Cola came into existence. But still, they are having that right, without disclosing what it is. Others have tried it, Pepsi-Cola and all that. Still, they have not been able to match with that of Coca-Cola. Next one. Say famous trade secrets. KFC, Kentucky Fried Chicken. Its recipe is not known to anyone, only few people. Those are directly connected with it. What they are doing is they are preparing it at one place where it is so confidential, they will take it to another place and give it to them. So may give it to me, I can mix it and make Kentucky Fried Chicken. But what is important is the recipe. What is important is the recipe. That recipe is a secret. However I try, I may not come with it. But I can use it. Dairy milk, Cadbury's dairy milk. So all these things are there. Next one. Shh, don't tell anyone. Don't tell anyone. Information that not known outside of an organization that provides a competitive advantage. The formula of Coca-Cola is known within that company only. It is known to only few people, I think 3 or 4 people. That's all. They make it and give it to others. They will add it to water, whatever it is, and then they bottle it. But how that water is converted to Coca-Cola, no one knows. Formula for Coca-Cola decided not to patent, to keep secret forever. KFC's secret recipe, only 3 executives have access to the recipe. Only 3 executives or KFC know what the recipe is. Guarded in a bank vault. Secret is kept in a bank vault. Company mixes the formula in only 3 facilities. They make it in 3 facilities to maintain the secret. So if you are having some product which is to be kept as a secret, try to follow this. Next one. Last one is protection of plant varieties and farmers' rights. It is granting rights to 3 sets of people. This protection is for a new variety. They will breed, maybe taking to parent stock, they breed it and come out with a new one having better qualities, maybe providing high yield, better taste, and so on. So a new variety, if it conforms to the criteria of novelty, should not be existing till then, that particular breed or variety. It should be distinctive and also stability. You have a crop, say black pepper. This season you are getting good crop. Next season you are not getting it. So it has no stability. Should be repeatedly and stably giving it, maybe for years. That is one criteria. An extant variety, if it conforms to the criteria, next one. Extant variety means notified under section such and such, a farmer's variety, a variety about which there is common knowledge, and any other variety which is in the public domain. That also can be patented provided it satisfies the conditions of distinctiveness, novelty, etc. Next one. And breeders have the right. Whoever is breeding it, they have the right to produce it, to sell it, and so on. Researchers have rights. They will be using the existing stock obtained from a farmer. Then he is also permitted to use it. Like that, when I mentioned about copyright, I said it cannot be xeroxed or copied, but for academic purpose it is exempted. Students can take copies of that, have xerox copies of a copyrighted article thing, the book which I show, but not the entire book. Entire book is not permitted. The few pages for which your for your academic purpose, if it can be used, but not the entire book. Don't sell it also. After, but many of you are maybe copying the entire book and using it, but mostly for your academic purpose only, and therefore there will not be that sort of an objection. And farmers also have the right. Next one. Okay, so I mentioned about all the 8 types of IPRs enforced in India. In some cases, you may require multiple protection. Like, you see here a writing pen. Take the case of a writing pen. Patent the ink flow mechanism. The ink flow mechanism, like the nib the nib, feeder, etc. All those things come under patents. So you can patent it. Next, industrial design. Pen makers are coming in with a lot of designs to attract. Different colors, different shapes. All these are coming under designs, shape of body, shape of clip, etc. Copyright. It will have an engineering drawing. It will have an engineering drawing, and that is protected as a copyright. Then trademark. You have Parker, Pilot. All these are trademarks. Then trade secret, natural dye for color from a plant. In some cases, the ink which they are using is produced by certain process. That is kept as a secret, like the Coca-Cola. Its formula is not known to anyone. So as far as maybe your ball pen ink, once it is filled, you can't do that. The other one, fountain pen, you are getting ink separately and then you are using it. But what about the ball pen? That is made by the manufacturer itself. That formula only those people do. So it comes under trademark. Then plant variety. What plant is used for making that ink? See, for a simple article like a pen, it qualifies for different types of IPR rights. IP rights, like patents, industrial design for shape, copyright for engineering drawing, trademark, trade secret for the natural dye, plant variety, geographical, after 50 years or more of reputation is maintained. Say the plant from which they are taking the dye may be in a certain area. If you cultivate that elsewhere, it may not produce the same result. That is why it is having the geographical indication. Next one. Trademark versus patent versus copyright. Trademark here, megawatt. Megawatt is a trademark. So as far as this is concerned, patent, how Dr. Ludwig made it, that is eligible for patent. Copyright, an advertisement on TV, which is a copyrighted article. Next one. So when you talk about intellectual property, there is a creation, there is an application, there is a protection, and then it ends in successful business. So first you have got to create it, and then there has got to be applied, application, then protection through IPR, and finally it comes to successful business. Because others cannot produce it. Others cannot produce it. So you are entitled to the entire monetary benefit from that. Next one. So multiple protection in many cases. Okay, next one. Next one. A treadmill. Brand name, service name comes under trademark, service mark, IC layout, all those things are there. Next one. World, we have, besides Indian Patent Office, there is another organization which is controlling the patents the world over. That is known as WIPPU, World Intellectual Property Organization. This is the site. Next one. Okay. This is all about, more about patents. If you are interested, I can. What slides are there? Next one. There are 4 patent offices. One is in Calcutta, another one in Delhi, Bombay, and then Chennai. Those from southern India, South India has to apply in the Chennai office, not in the Calcutta office. So when you are applying for a patent, for any product invented in Kerala, you have to apply with the Chennai Patent Office. Next one. Okay, next one. Previous. Next one. Yeah, an invention. When you apply for a patent, it has to be for an invention. What is an invention? Or a process also. It can be a product or a process. For both, it is possible. Which is new. It has got to be new. It should not be existing till then. Should involve an inventive step and capable of being industrially produced. Say, take the case of a bucket. Imagine that you have a bucket without the handle. Say it's a 20-liter bucket. Maybe something like the basin. How many hands are required when it is full? How many hands are required? You require 2 hands to carry it with a basin full of water of 25 liters. Where will you carry it? Where will you hold it? In front of you. With both hands you are holding the basin and holding it in front of you. So it's very inconvenient. You have to use both your hands. You have to carry it in front of you, which is obstructing your walking. So somebody thought how it can be improved. What has been done? What has been done? They incorporated a handle onto it. They incorporated a handle, which is an inventive step. It was not existing till then, till it was incorporated for the first time. Earlier, without the handle, you are carrying it with both hands, you are holding it in your front, which was obstructing your walking and so on. After incorporating the handle, now how many hands are required to carry it? How many hands are required? Only one hand is required. Where will you hold it? Will you hold it in your front? You will hold it by the side. Is it interrupting your walking? It's not interrupting your walking. See the improvement which has taken place. What is the inventive step there? Incorporation of the handle is the inventive step. Otherwise, bucket carrying water is the same. Whether having a handle or without the handle, it is the same. But now it has improved the utility of that. So your invention, inventive step, should concentrate on improving the utility of the article. Next one. Who can apply for a patent? The true and first inventor or the assignee. You can ask someone else also to do that, provided there is a condition between you, agreement between the two. Or it can be done by your patent attorney also. Either you can do it on your own, you can ask your son to do it, or your friend to do it, who is your assignee, and then also the patent attorney can also file. Next one. File an application in the patent office with complete specification. When I say complete specification, all the details. What are the existing art? What is your improvement that has been brought about? What all those improvements are? How they have been brought about? These things have got to be mentioned, which is known as a complete specification. There is another important thing which you have to bear it in your mind. Say complete specification or provisional specification. Say you have an idea. Say I said the bucket, an inventive step of providing a handle to it. So you go to the workshop, ask one person, a technician, ask one to make a handle, and then drill holes on the sides. You fix it. Someone else is seeing it. When you are doing that, it's your idea. Incorporation of a handle to the basin is your idea. Since you can't do it on your own, you are taken it to the workshop or to a fabrication shop. You are asking someone else to do it for you. There may be a smarter fellow there. He understands all those things. He'll make an application for patent. He'll apply with the patent office. You are waiting to complete the job, test it, and be satisfied. After that, you apply for the patent. By the time this application is already there, even though it's your idea, you have to forgo that. That is where the second part of this professional specification comes into picture. You have an idea, approximately these are the components and all that. You make a write-up, you haven't worked it at all, apply with the patent office, yours is registered with the patent office, now you have time, 12 months time to complete it. Within that 12 months time, you complete it, you apply for the patent, even if someone else's copied in invention is applied, yours is already there. The moment you had the idea, you prepare the draft and send it to the patent office as provisional specification. And then after completing and testing, after being satisfied, apply with the complete specification. That is, you are following the thing, the provisional with the complete specification. So always remember that. If you have an invention, before making it public, since there are chances for others to copy it and others to apply for the patent, don't do that first time itself. You apply for the patent with provisional specification, you have 12 months time to complete it, and before 12 months time elapses with apply with complete specification. This has to got many people have lost their chances for getting a patent because they didn't do it like this. They made it public. Someone applied first. So the moment itself, because you have to show it to someone, because you have to take it to the workshop, to the machine shop or the fabrication shop. And when you are doing that, others are going to see it. So to prevent them, and you can overshoot them by applying with provisional specification, but then you have got to complete it, follow it up within 12 months time by filing complete specification. Next one. To be filed within 12 months from the date of filing. No extension of time is allowed. Next one. These are the offices. Next one. So fees. Next one. Electronically also you can do that. There is a reduction in the fees. 10% reduction will be there. Next one. What are the criteria for patentability? Should be novel, should not be existing till then, should have an inventive step. As I said, the incorporation of the handle, which is an inventive step. It must be non-obvious, should be capable of industrial production, should not fall within the provisions of 3 and 4. For everything you won't get a patent. Next one. You have just to be followed up with the drawings and so on. Okay, next one. Next one. Next. Okay, once you have apply with a complete specification, normally the patent office keeps it for 18 months. And then it will be published in the journal for public to come to know about it. Why? Because yours may be a copy of someone else. It might have been displayed at an exhibition, in a private exhibition. So I apply for the patent. He comes to know about it. I have already displayed it at an exhibition. So I organized it in my college, which is private. So he can raise an objection, saying that this is an item, invention, already displayed at such and such exhibition. So he can put an objection to that. Patent office will consider that. They will ask for my clarification. I should be able to satisfy them. He has produced all the proof, photos, paper reports and everything it is there. So that way you lose your chance. That is why they are publishing it in the journal for others to come to know. Normally they publish it in 18 months time, but now there is another exemption for that. You can apply for early publication. If it is early publication, within 1 month of your application filed and out, they will publish it within 1 month. Otherwise they will wait for 18 months. So better to do it earlier. Okay, next one. Okay, next. So early publication, now it is, rule is there. Next one. Similarly, early examination also. When I applied for the patent for one item in 1995, I got it in 2005. It took 10 years time. It took 10 years time. Later, the patent office, they appointed more number of people, and finally, they started giving it in 2 years time. Again, it increased to 6 years. Now they have provided a provision for early examination, but a big fee is there. Early examination means immediately they will do that within a short period of time, and then it may be granted that you provided everything is in order. Earlier that provision was not there. Early publication was also, when I applied, early publication was also not there. See, apply and then you make quiet. Wait for the things to come. Next one. It is not examined automatically. You have to apply for it. For examining your patent documents. Next one. Next one. Next one. When they examine it, if there are certain objections, they will let you know. So when I applied for a patent first time in 95, there was an objection from the patent office saying that compared to a patent number such and such of the United States in 1927, prima facie yours is lacking in novelty. With respect to patent number such and such of United States granted in 1927, yours is lacking in novelty. That was the objection from the patent office. By that time, we had obtained the details of that patent. So we prepared a table. What are the features of ours? How many fulcrums are there? Whether it is a foot lever or a hand lever, and so on. There's how many fulcrums are there? How many levers are there? Whether the lever is upturned or whether it's a foot lever or a hand lever, and so on. We clarified that, and based on that they granted us, because it was different. There was an inventory step. Theirs was foot operated, ours was hand operated. I'm talking about the coconut husking tool, which we all of you must be having it at your home, or most of you must be having it at your home. A lever assisted husking tool. So there was something similar to that in United States in 1927, but that was foot operated. Ours is what? Hand operated. The other one you are pressing the lever down. This one you are lifting the lever upwards. So when we said all those things, they granted to us because ours is different. So those way you are got to do that. Next one. Next one. Now opposition can come before your granting or after granting also. After granting, you have to apply within 1 year's time. Next one. Next one. Your college can get a patent journal in the library if they are not having it. Next one. This one. Say in some inventions, when you buy the article, it may be written on the cover, patent pending. Patent pending. Say some people are misusing it because you cannot use this term in the case of an invention which has not been applied for patent. You have not applied for the patent. You have an invention. You start manufacturing it and you are selling it. On the cover it is written patent pending. But at the same time, what is the truth? You haven't applied. This is a criminal offense. To mislead the public is a criminal offense. You can be prosecuted for that. So if you have an article, you are producing it, don't write on it patent pending unless you apply for the patent. After having applied for the patent, it is registered with the patent office, you can use the term patent pending. Till then, should not use it. Next one. Or patent applied for. Only if you are applied for, you can write. Patent pending or patent applied for, both these phrases can be used only if you are applied for the patent. Till then, not at all. Next one. Okay, if your invention, whether it is already patented, you search the patent office, go to the site and then you can search and find out, or giving all index terms. With that you can find out whether it's already patented or not. Patent office, now you've got the internet, anything you can obtain. Next one. Okay, another thing is patent is for 20 years. Totally, you can make use of a patent for only 20 years. Beyond 20 years, it is not permitted. It loses the validity. So validity exists only for 20 years from the date of application. So our patent is in 95 August. 2005, 10 years. 2015, by 2015 it is over. There is no patent now. Valid patent is not. Patent is there, but valid patent is not. Anybody can make it. So your patent validity is only for 20 years. There are certain things going around saying that it's only for 15 years. It is incorrect. In the WhatsApp and all, somewhere I read that it is for 15 years. Not so. It is for 20 years. Next one. From the date of application, not from the date of granting. We applied in 95, 2015, 20 years expired, got the patent in 2005 after 10 years. So that one is for, even though it's for 20 years, we have the benefit for only 10 years. Next one. And you got to renew it every year, from third year onwards. Once the patent is granted, you got to renew it every year, unless the others you can renew after 10 years, maybe 15 years and so on. Patent every year you have got to renew it by paying the stipulated fee from third year on. First two it is exempted. First 2 years renewal fee is exempted, renewal is needed. But third year onwards you have to apply for renewal. Next one. You can pay it in terms of or annually also. This is a renewal fee. Next one. Next one. And this is another one. patent rights are territorial in character. Means, if you obtain a patent in India, it can be enforced only within the boundary of India. You cannot claim it in Malaysia, Singapore, Australia, and so on. If you want the rights in Australia, you have to apply to the Australian Patent Office and get the patent granted by them. Then it is possible. So there is nothing called international patent. Many people have asked about it. Whether international patent is there, it is not at all there. Whichever country you want to protect, apply it in that country. And that is called a PCT, Patent Cooperation Treaty, in which once you apply it here for the PCT, then you get a priority. Say America is a PCT country, you want to apply it in America. As I said, you have to separately apply it there. But if you apply it in India, say on June 1st, you apply in India for your invention. You have to complete whatever process are required. After that, in July, you apply in United States. June 1st, you have applied in India. July 1st, you are applying in United States. You can claim priority from June 1st. Even though your application there is in on July 1st. Clear? You get priority from the date on which you apply, only with respect to PCT countries. Otherwise, next. Okay. IIT Kharagpur, they have running law courses now. They are running law courses. So if you are interested in pursuing a career in IPR, you can go and study this. For MTech, there are courses. You will study all this, whatever I have said in detail, you will be studying there, and after that you can become a patent attorney. You can practice as a patent attorney. Many people are doing it now. It's not that only engineering courses are there. So, IIT Kharagpur was introduced. So there is one fellow in Malayali, he got first rank. Next one. Next one. Next one. So these are my, if you want to contact me for anything, any other thing, you can contact me with this number or the email ID. Next one. So thank you very much for your patient listen. If there are any questions, you're most welcome.
ട്രേഡ് സീക്രട്ട് നമ്മൾ ഡിസ്ക്ലോസ് ചെയ്യാൻ പാടില്ല എന്നല്ല പറഞ്ഞു. അപ്പോൾ എങ്ങനെയാണ് നമുക്ക് റൈറ്റ് എങ്ങനെ നമുക്ക് കിട്ടുന്നത്?
We apply for it, but I have heavy fees on it. അതുകൊണ്ടാദ്യം വരുള്ളൂ. പിന്നെ അത്രയ്ക്ക് ഇതുള്ളതിന് മാത്രമേ അങ്ങനെ എടുത്തോണ്ട് കാര്യമുള്ളൂ. കാരണം you have got to renew it by paying the fees. അപ്പോൾ ഇത് എടുത്തു വെച്ചുകൊണ്ട് ചുമ്മാ ഇപ്പം ഞാൻ നിങ്ങൾക്ക് സോഡ ഉണ്ടാക്കിക്കൊണ്ട് അത് വെച്ച് ഇത് ചെയ്യാൻ വേണ്ടിയിട്ട് കാര്യമൊന്നുമില്ല. ഈ കാശ് കൊണ്ട് വെച്ച് പക്ഷേ they are making money on it.
ഒരു ക്വസ്റ്റ്യൻ കൂടി, സാറിനൊരു പേറ്റന്റ് ഉണ്ടെന്ന് പറഞ്ഞല്ലോ, അതിന് ഫൈനാൻഷ്യൽ ബെനിഫിറ്റ് എങ്ങനെയാണ് കിട്ടിയതെന്നൊന്ന് പറയാമോ?
നിങ്ങൾക്ക് ഫൈനാൻഷ്യൽ ബെനിഫിറ്റ് കാര്യമായിട്ടൊന്നും കിട്ടിയില്ല എന്നുള്ളതാണ്. ബിക്കോസ് വി ടുക്ക് എ ഡിഫറെൻറ്റ് പോളിസി. ഞാൻ പറഞ്ഞു വരുന്നത് ഫിനാൻഷ്യലി മൂന്നാമത്തേനെ ട്രൈ ചെയ്തുകൊണ്ടിരിക്കുകയാണ് ഫോർ ട്രാൻസ്ഫർ. ബട്ട് ഫസ്റ്റ് വൺ തേങ്ങ വിളിക്കുന്ന സാധനമാണ് എല്ലാവരും ഉപയോഗിക്കുന്നത്. അതിന് പേറ്റന്റ് എടുത്തതിന് ശേഷം വി ട്രാൻസ്ഫേർഡ് ഇറ്റ്. പേറ്റന്റ് എടുത്തതിന് ശേഷമല്ല, ആഫ്റ്റർ അപ്ലൈ ഞങ്ങളത് റെയ്ക്കോ എന്ന് പറഞ്ഞ സ്ഥാപനത്തിന് കൊടുത്തു. റീജിയണൽ അഗ്രോ ഇൻഡസ്ട്രിയൽ ഡെവലപ്മെൻറ്റ് കോപ്പറേറ്റീവ് ലിമിറ്റഡ് കണ്ണൂരിലുള്ള ഒരു സ്ഥാപനമാണ്, അവർക്കാണ് അത് കൊടുത്തത്. അപ്പോൾ അന്ന് ഒരു 10,000 rupees ലംസം എമൗണ്ട്, പിന്നെ 2% റോയൽറ്റി ഓൺ എവറി പീസ് സോൾഡ്. 10,000 rupees ഞാൻ എൻ്റെ ഒരു പാർട്ട്ണറും ഉണ്ട്. ഞങ്ങൾ എൻ്റെ സ്റ്റുഡൻറ്റ് എൻ്റെ കൊളീഗായിട്ടിരുന്ന ജോബി പാസ്റ്റനുമുണ്ട്. ഞങ്ങൾ രണ്ടുപേരുടെയും കൂടെ പേരിലാണ് പേറ്റുന്നത്. പിന്നെ യൂണിവേഴ്സിറ്റി ഉണ്ട്, അഗ്രികൾച്ചർ യൂണിവേഴ്സിറ്റി ഉണ്ട്. അപ്പോൾ 10,000 rupees ലംസം എമൗണ്ട് അഗ്രികൾച്ചർ യൂണിവേഴ്സിറ്റി എടുത്തു. പിന്നെ റെയ്ക്കോ ഉള്ള എഗ്രിമെൻറ്റിനകത്തൊന്ന് ഫസ്റ്റ് 5,000 പീസസിന് ദേ ആർ എക്സെപ്റ്റഡ് ഫ്രം പേയിങ് റോയൽറ്റി. ഫസ്റ്റ് 5,000. അപ്പോൾ ഫസ്റ്റ് ഇയർ 96-97 they sold 15,000, around exact number അല്ല, around 15,000. They were exempted from paying for 5,000 pieces. അപ്പോൾ അത് മാറ്റിക്കഴിഞ്ഞിട്ട് we got the royalty for 150 രൂപയ്ക്കാണ് ഏകദേശം വിറ്റിരുന്നത്. അപ്പോൾ 3 രൂപ വെച്ച് ഒരു പീസിന് വെച്ച് കിട്ടുന്നത്. അപ്പോൾ അതിൽ 10,000 എണ്ണത്തിൻ്റെ റോയൽറ്റി 3 രൂപ വെച്ച് കിട്ടിയതിൻ്റെ പകുതി കാശ് യൂണിവേഴ്സിറ്റി എടുത്തു, പകുതി ഞങ്ങൾക്ക് 2 കൂടെ തന്നു. അത് ഞങ്ങൾ 2 പേരും കൂടെ തിരിച്ചെടുത്തു. 7,000 വെച്ചാണ് കിട്ടുന്നത്. സെക്കൻഡ് ഇയർ ആയപ്പോൾ, അതായത് 97-98, they sold only 10,000. ഫസ്റ്റ് ഇയർ 15,000 വിറ്റവർ സെക്കൻഡ് ഇയർ ആയപ്പോഴത്തേക്കും 10,000 എണ്ണം വിറ്റു, 5,000 പോകും, അറൗണ്ട് 9,000. അതിൻ്റെ പകുതി റോയൽറ്റി കോളേജ് യൂണിവേഴ്സിറ്റി എടുക്കുന്നത്, ബാക്കി പകുതി ഞങ്ങൾക്ക് വരും. അപ്പോഴത്തേക്കും നാട്ടിൽ പലയിടത്തും ഇത് ഉണ്ടാക്കാൻ തുടങ്ങി. ഒരുപാട് ഫാബ്രിക്കേറ്റേഴ്സ്, ആകെ ഒരു കട്ടിങ് മെഷീൻ, ഒരു വെൽഡിങ് ഷോപ്പ് ഉണ്ടെങ്കിൽ സംഭവം ഉണ്ടാകും. സോ സ്റ്റാർട്ടഡ് മാനുഫാക്ചറിങ്. വി കുഡ് ഹാവ് സ്റ്റോപ്ഡ് ബട്ട് വി ഡിഡ്. Then third year they sold around 5,000 pieces. 15, 10, 5,000. അതിൻ്റെ പകുതി ഓഫ്കോഴ്സ് യൂണിവേഴ്സിറ്റി എടുത്ത് വരുന്നുണ്ട്. ബൈ ദ ടൈം പലരും ഉണ്ടാക്കാൻ തുടങ്ങി. എനിക്ക് ഞാൻ ഇത് മാർക്കറ്റിൽ വന്നു എനിക്കൊന്ന് 4-5 മാസമായി കാണുള്ളൂ. ഞാനിങ്ങനെ ബസ്സിറങ്ങി എൻ്റെ വീട്ടിലേക്ക് നടന്നു പോകുമ്പോൾ എൻ്റെ മുൻപിലായിട്ട് ഇടവഴിയിൽ നിന്നൊരു ആള് തോളത്ത് 5-6 ഇത് വെച്ച് ചറിഞ്ഞു, ഈ തേങ്ങ വയ്ക്കുന്ന സാധനം. അപ്പം ഞാൻ കണ്ടപ്പോൾ ചോദിച്ചത് എന്താ ഈ സാധനം എന്ന് ചോദിച്ചു. അപ്പം ഇത് തേങ്ങ വയ്ക്കാനുള്ള സാധനമാണ്. എനിക്ക് കണ്ടിട്ട് അത്ര ഗുണമൊന്നും തോന്നുന്നില്ലല്ലോ. അല്ല സാറേ, ഇത് നല്ലതാണ്. ഞാനിതുമായിട്ട് ഓരോ വീട്ടിൽ ചെന്നു. രാവിലെ 10-15 ഇറങ്ങും വീട്ടിൽ നിന്ന്. എന്നിട്ട് ഓരോ വീട്ടിൽ കയറിയിട്ട് അവിടെ ചെന്നിട്ട് അവിടെ തേങ്ങ ഉണ്ടാവില്ല. ആ തേങ്ങ എടുത്തിട്ട് പൊതിച്ച് കാണിച്ചു കൊടുക്കും, അവരോട് പൊതിക്കാൻ പറ്റും. അപ്പോൾ അവർ വരും. അപ്പം പിന്നെയാണ് ഒരു 3-4 മുട്ടയിൽ ബാക്കി തോളത്ത് വെച്ചാൽ പോകുന്നത്, കുന്തവും വെച്ചിരിക്കുന്നത്. അപ്പം എന്നോട് ചോദിച്ചു, സാറിന് വേണമെന്ന് ചോദിച്ചു. ഞാൻ എനിക്കിപ്പോൾ വന്ന് കണ്ടിട്ട് കൊള്ളാമെന്ന് തോന്നണ്ടേ, എനിക്കിപ്പോൾ വേണ്ട, പിന്നെ ഞാൻ മേടിച്ചോളാമെന്ന് പറഞ്ഞ് ഞാനങ്ങനെ അവിടെ പോവുകയും ചെയ്തു. പുള്ളി അങ്ങ് പോവുകയും ചെയ്തു. വേറൊരു ദിവസം അതിൻ്റെ അടുത്ത ദിവസം തന്നെ ഇങ്ങനെ ബസ്സിൽ വരുമ്പോൾ ഒരു കുട്ടി, 10-12 വയസ്സുള്ളൊരു ആൺകുട്ടി, ഇതുവരെ 3 തോളത്ത് വെച്ചിട്ട് ബസ്സിൽ കയറി. അപ്പം നെക്സ്റ്റ് സ്റ്റോപ്പ് എനിക്ക് ഇറങ്ങാനാണ്. ഞാൻ എഴുന്നേറ്റ് ബസ്സിൽ നിൽക്കുക. ഈ കുട്ടി ബസ്സിൽ കയറിയിട്ട് ബസ് അപ്പോഴത്തേക്ക് സ്റ്റാർട്ട് ചെയ്തു. ഈ ലോസ് ഇസ് ബാലൻസ്. അപ്പോൾ പെട്ടെന്ന് ഈ കാലെല്ലാം കൂടെ 3-4 കാലെല്ലാം താഴോട്ട് വെച്ചു. അത് എൻ്റെ കാലിന് പുറത്താണ് വെച്ചത്. ഞാൻ കാലുകൾക്ക് വരുന്നു. അപ്പോഴത്തേക്കും അടുത്ത സീറ്റിൽ ഇരിക്കുന്ന ആള് ആ കുട്ടിയോട് ചോദിക്കുന്നുണ്ട്, എന്താണെന്ന് ചോദിക്കുന്നു. ഇവിടെയൊന്നും അതുവരെ കണ്ടിട്ടില്ല. ആ പറഞ്ഞിങ്ങനെ തേങ്ങ വിളിക്കാനായിട്ടാണ് നല്ലത്. അപ്പോഴത്തേക്ക് എൻ്റെ സ്റ്റോപ്പായി, ഞാനങ്ങനെ ഇറങ്ങിപ്പോയി. വാട്ട് ട്രാൻസ്ഫേർഡ് ബിറ്റ്വീൻ ദം എന്നുള്ളത് കേൾക്കാൻ പറ്റിയില്ല. അപ്പോൾ ഞാൻ വിചാരിച്ചു എന്തായാലും എനിക്ക് സ്ട്രൈക്ക് ചെയ്ത് എനിക്ക് ടിക്കറ്റ് എക്സ്റ്റെൻഡ് ചെയ്തിട്ട് ഞാൻ അവരുടെ കൂടെ പറയും, ഇവിടെ ട്രാവൽ ചെയ്തിട്ട് അന്നത് ഇറങ്ങിയിട്ട് അധികം നാളായിട്ടില്ല. അപ്പോൾ അതിൻ്റെ റെസ്പോൺസ് അറിയാനായിട്ട് നമുക്കൊരു എൻതൂസിയാസം ഉണ്ട് അതിനകത്ത്. ബട്ട് ഐ മിസ് ദാറ്റ് ഓപ്പർച്യൂണിറ്റി. അതിനുശേഷമാണ് എ തോട്ട് കെയിം ടു മൈ മൈൻഡ്. ഈ 2 പേരും അവരുടെ ഡെയിലി ബ്ലഡ് ഉണ്ടാക്കാൻ വേണ്ടിയിട്ടാണ് ഈ സാധനം വിറ്റുള്ളത്. തോളത്ത് വെച്ചിട്ട് ഇറങ്ങി വീട് വീടാന്തരം കയറി നടന്നിട്ട് വിൽക്കുക. 12 വയസ്സുള്ള ആൺകുട്ടി വീട്ടിൽ അത്രയ്ക്ക് പ്രാരാബ്ദമുള്ളതുകൊണ്ടായിരിക്കുമല്ലോ ഇത് വിൽക്കാനായിട്ട് സ്കൂളിൽ പോകാതെ, സ്കൂളുള്ള ദിവസമാണ് നടക്കുന്നത്. Then we thought, let it be freely manufactured. ആര് വേണേലും ഉണ്ടായിക്കോട്ടെ, ആര് വേണേലും വിറ്റോട്ടെ. Of course, we lost crores. ഇതിൻ്റെ അന്നത്തെ എസ്റ്റിമേറ്റ് ഞങ്ങളുടെ കേരളത്തിൽ നിന്ന് 55 ലക്ഷം വീടുകളുണ്ട് കേരളത്തിൽ. 35 അല്ലെങ്കിൽ 30 ലക്ഷം വീടുകളെ മേടിക്കുന്നുള്ളൂ. 1 രൂപ പ്രോഫിറ്റ് എടുത്താൽ 30 ലക്ഷം രൂപ പ്രോഫിറ്റാണ്. അന്ന് വിറ്റിരുന്നത് 150 രൂപയ്ക്ക് വിൽക്കുമ്പോൾ അതിൻ്റെ മാനുഫാക്ചറിങ് കോസ്റ്റ് വാസ് ഓൺലി അറൗണ്ട് 40-50 റുപ്പീസ്. അപ്പം ഏകദേശം 100-110 രൂപ പ്രോഫിറ്റിനാണ് അന്നത് വിറ്റുകൊണ്ടിരുന്നത്. ഗ്രേഡ്കോ അത് 5 ലക്ഷം യൂണിറ്റ് വിൽക്കുകയാണെന്നുണ്ടെങ്കിൽ തിങ്ക് ഓഫ് ദ പ്രോഫിറ്റ് എമൗണ്ട്. ബട്ട് ഞങ്ങൾ ആ ഒരു ഫ്രീ ആയിട്ടൊരു പോളിസി എടുത്ത കാരണം വാട്ട് ഹാപ്പൻഡ്, കേരളത്തിലെ മാത്രമല്ല ഇന്ന് ഇന്ത്യ മുഴുവൻ തന്നെ പല ഇൻഡസ്ട്രീസും ഇതുണ്ടാക്കി. ഈ അടുത്ത് ഞങ്ങൾക്ക് ഷൊർണൂർ വിളിച്ചിട്ട് ഞങ്ങൾക്ക് ഒരു റിസപ്ഷൻ തരികയുണ്ടായി. ഷൊർണൂർ about 30 മാനുഫാക്ചറേഴ്സ്, അവരുടെ ഇൻഡസ്ട്രിയൽ എസ്റ്റേറ്റും അതിൻ്റെ നിയർ ബൈ ആയിട്ട് 30 ഇൻഡസ്ട്രിയൽ എസ്റ്റേറ്റ്സ് ആർ മാനുഫാക്ചറിങ് ആൻഡ് സെല്ലിംഗ് ദിസ്. അവർ ഞങ്ങൾക്ക് വിളിച്ചത് എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ ഇത് വരുന്ന സമയത്ത് അവർക്കൊരു റിസഷനായി, അവർക്ക് വിൽക്കാനൊന്നുമില്ല, ആൾക്കാർക്ക് പണിയില്ല. അങ്ങനെ ബുദ്ധിമുട്ടി ഇരിക്കുന്ന സമയത്താണ് ഈ സാധനം വന്നത്. സോ ദേ സ്റ്റാർട്ടഡ് മാനുഫാക്ചറിങ്. വേറെ റെസ്ട്രിക്ഷൻ ഒന്നുമില്ല, പേറ്റന്റ് ഇതൊന്നും ആരും ഇൻസിസ്റ്റ് ചെയ്യുന്നില്ല, ചെയ്യേണ്ടത് ഞങ്ങളാണ്. വി ആർ നോട്ട് ഡൂയിങ്. എന്നിട്ട് ദേ സർവൈവ്. അതിനകത്ത് അതിൻ്റെ സന്തോഷമായിട്ടാണ് അവർ ഞങ്ങളെ വിളിച്ചിട്ട് ഈ ഓഗസ്റ്റ് 30th 15th ഞങ്ങൾക്കൊരു റിസപ്ഷൻ തന്നു. ജസ്റ്റ് ബിക്കോസ് ഈ സാധനം. അപ്പോൾ ഇതുകൊണ്ട് പല കാര്യങ്ങളുണ്ട്. യു ക്യാൻ മേക്ക് യൂറോ മണി. ഞാൻ വലിയ പൈസക്കാരനൊന്നുമല്ല, ബട്ട് സ്റ്റിൽ മൈ തോട്ട് പ്രോസസ് ഇസ് ഡിഫറെന്റ്. ഫ്ലോറിഡയിൽ ഞങ്ങളുടെ ഏരിയ ഉണ്ട്. സോ വി ഹാവ് റിക്വസ്റ്റ് ഫ്രം ഫ്ലോറിഡ, ക്യൂബ, ഓസ്ട്രേലിയ. ഈ ഷൊർണൂരിലെ ഒരു കമ്പനിക്കാരുടെ അടുത്ത് നിന്ന് ഓസ്ട്രേലിയയിലേക്ക് 500 പീസസ് ദേ വാണ്ടഡ്. ഒരു 200 രൂപ. So these things are like that.
Now I would like to invite Parmeshwar Namboothri, student coordinator of IEDC, to give the talk.
Respected sir and beloved faculty, it has been such an honor to be part of this very informative session. On the behalf of iedc and SBCE, I would like to extend my heartfelt gratitude to Dr. JIPPU JACOB sir. Thank you, sir. Thank you. Next, I would like to thank Dr. Rijo sir, Khalid sir, and everyone for supporting us. Finally, I would like to thank all of you present here. Thank you.